Hello everybody, welcome to juriscentral.com online classes for law exams. So today I will be dealing with you Prevention of Money Laundering Amendment Act 2019 for your upcoming UPSC CBI APP exam and also Delhi APP exam and other related exams which is to be conducted on 19th of September 2021 as your syllabus is just the same for the given post. So let us start. This article apprises subjects with various key amendments in the Prevention of Money Laundering Act 2002. So let us understand when this act came into force. PMLA and the rules notified thereunder came into force with effect from 1st of July 2005. That means this amendment also came into force from this date called 1st of July 2005. The preamble of the act applies that it is an act devised to, that means the objectives of the act are prevent money laundering, then provide for confiscation of property derived from or involved in laundered money and punish those who commit the offense of money laundering. So this is the objectives of the act. There are three stages to a transaction of money laundering. Now let us understand. The first stage is placement, where the criminals place the proceeds of the crime into normal financial system. So this is the first stage, which is called placement. The second stage is layering, where money introduced into the normal financial system is layered or spread into various transactions within the financial system so that any link with the origin of the wealth is lost. Layering means putting one over the other. So it means it's generally done to extinguish the origin of the proceeds of the crime. The third stage is integration, where the benefit or proceeds of crime are available with the criminal as untainted money. So the integration part is the third stage, in which the benefit is actually shown that the proceeds are received as an untainted money. That means not as a black money but as a white money. The definition of money laundering is provided under section 3 of the PMLA 2002, which states that, so now we'll understand the definition of money laundering which is given under section 3 of the Prevention of Money Laundering Act 2002. Whosoever directly or indirectly attempts or indulge or knowingly assists, knowingly is part or is actually involved in any process or activity connected with the proceeds of crime, including its concealment or possession or acquisition or use, and projecting and claiming it as untainted property, shall be guilty of offense of money laundering. It therefore emerges that the definition is a very wide definition and is not exhaustive, and almost any kind of dealing with the proceeds or fruits of crime is brought within the scope of the section. It means like the proceeds of crime, which is it doesn't matter what it is source, but any kind of illegal money received as the proceeds of crime is actually considered as money laundering. The word proceeds of crime has been underlined above because of the imperative nature it carries, as the offense of money laundering as defined above, a liability for punishment under section 4 is attracted only when the laundered property falls within the definition of proceeds of crime. So let us understand, section 3 actually deals with the definition of money laundering, and section 4 deals with the punishment of money laundering, and the person is actually liable for punishment only if it is shown that he has received that amount as proceeds from crime, and if the prosecution fails to show the same, then that person is not responsible or not liable under section 4. So proceeds from crime is an ingredient of the offense of money laundering. The PMLA also enumerates a list of offenses which are classified as scheduled offenses, constitute as crimes. The growing number of financial crimes and high profile embezzlement have become a matter of grave concern, as a result of which the Finance Act 2019 has introduced few amendments to the PMLA to curb the same. So this is important. So this amendment have been brought into effect by the Finance Act 2019, and the act has only amended the PMLA Act to counter the financial crimes and the high profile embezzlement that have become a matter of grave concern. Now we'll discuss the key amendments. Explanation to Section 2 Clause U. So this is the explanation which has been attached by this amendment. Explanation to Section 2 Clause U inserted. This explanation clarifies the position of proceeds of crime. Now proceeds of crime will be understood to relate to any property that directly or indirectly derived or obtained through any activity relatable to scheduled offences. So it actually defines, this explanation actually clarifies that, first of all, let me tell you, Section 2 Clause U deals with proceeds of crime, and this explanation clarifies that any property that directly or indirectly derived or obtained through any activity relatable to what? Scheduled offences. So those those will be relating to proceeds of crime. Accordingly, offence of money laundering is not an independent crime and depends upon another crime, which is known as the scheduled offences, the proceeds of which are made the subject matter of crime of money laundering. So this crime of property has to be done in relation to the scheduled offences which is given under this act. Explanation to Section 3. So this is also added. Section 3 of PMLA relates to offences of money laundering. The explanation under section mentions a person shall be guilty of money laundering if the person is directly involved or is knowingly a party to one or more of the following processes connected with the proceeds of crime. So these are the following processes, and it is actually connected with the proceeds of crime. And if it is shown that it is connected in some or the other way as given under Section 3, then only that person will be liable for offence of money laundering. So let us see what are the connected crimes with the proceeds of crime, like concealment of the same, like concealment of the proceeds of crime, possession of the proceeds of crime, acquisition of the proceeds of crime, use, projecting as untainted property, claiming it as untainted property in any manner whatsoever. So this is the new explanation added under Section 3. The explanation also states that the process or activity connected with proceeds of crime continues till such time a person is directly or indirectly enjoying the proceeds of the crime. So it means that till that person is enjoying the proceeds of the crime, the process or the activity connected with the same will also continue with the enjoyment. The above explanation was inserted on the basis of an observation made by Financial Task Action Force that concealment, possession, acquisition and use of the proceeds of crime were not criminalized earlier under Section 3 of the PMLA. So this explanation is inserted on the lines of the observation made by Financial Task Action Force, and this is actually something new because these processes were not there before this amendment of 2019. Proviso to Section 17 Clause 1 and 18 Clause 1 omitted. So let us understand. Omitting the above provision now gives the authorized officer under PMLA the authority to enter any property for the purpose of conducting search and seizure and the search of any person. So Section 17 and 18 deals with conducting search and seizure and search of any person respectively, even in the absence of the reporting of a scheduled offence to magistrate or any other competent authority in this regard. Where prior to the amendment it was provided that no search also including person shall be conducted unless in relation to the scheduled offences a report has been forwarded to a magistrate under Section 157 of the Code of Criminal Procedure, which sets out the procedure for investigation, and a complaint has been duly filed by a person authorized to investigate the offence mentioned in the schedule before a magistrate or court or taking cognizance of the scheduled offences as the case may be. So with this amendment, the proviso to Section 17 Clause 1 and 18 Clause 1 is omitted, and now the investigation officer can conduct search and seizure and search any person even in the absence of forwarding the report to the magistrate, that means taking permission from the magistrate before conducting any search and seizure. So the investigation officer has presently has not to take any kind of permission from the magistrate, or has to submit report in this regard before taking out any search and seizure. Amendment to Section 44 of the PMLA. Section 44 of the PMLA encompasses the provisions for offences which can be tried by special court. So Section 44 deals with what? It deals with offences which can be tried by special courts. Here the offences are scheduled offences and they are actually tried by special courts. A proviso has been inserted. So a proviso has been inserted under Section 44 to Section 44 clause 1 subclause B. So proviso has been added under Section 44 subclause 1 subclause B of the PMLA, which talks about submitting of a closure report upon conclusion of investigation. It states that if no offence of money laundering can be determined after investigation, the court shall submit a closure, the authority shall submit a closure report before the special court. It insists on closing of cases where investigation was completed and no offence was found. So actually special power is given by this proviso to the authority, that means to the investigation officer, that if upon any investigation no offence is made out against that person, then that investigation officer can file a closure report before the special court, that means closing of the case before the special court. An explanation has been inserted to Section 44 clause 1 subclause D, and also an explanation has been added to the subsection 44 clause 1 clause D of PMLA, which gives the special court an exclusive jurisdiction regarding the scheduled offences. The explanation mentions that the trial conducted by the special court for scheduled offences shall be distinct from any other trial being conducted for the same scheduled offence. It shall not be considered as a joint trial. So by this amendment, a special jurisdiction has been conferred to the special court, that in case if the special court is trying out any trial regarding any offence given under this act, then it doesn't have to get bothered about the trial of the same offence by some other court. It shall not be considered as a joint trial, and it is also given that the trial conducted by the special court and the same trial conducted by some other court, these two simultaneous trials won't be considered as a joint trial. The explanation further adds that complaint shall include any subsequent complaint that arises as a result of further investigation against any accused person. It also, the explanation also further adds that suppose if the complaint has been filed by the investigation officer and after that a subsequent complaint has also been filed, then even that subsequent complaint will also will also be a part of the original complaint. It shall be applicable for all persons whether or not such person was included in the original complaint. Then explanation to Section 45 clause 2 of PMLA. This explanation injected in Section 45 clarifies that the offence of money laundering is a cognizable and non-bailable offence. Now this is important. So this is the new explanation which has been added to Section 45 clause 2, which actually provides that the offences which has been given under this act will be cognizable and non-bailable. That means a person liable for any offence under this act can be arrested without warrant. Accordingly, an authorized officer can arrest the accused without a warrant, which in common parlance means that a person arrested is not entitled to bail as a matter of right, and the bail becomes a matter of discretion for the court. And if the offence provides for the punishment which more than 3 years, and bail can only be granted after hearing the prosecutor and only after the court comes to the conclusion that there are reasonable grounds for believing that he is not guilty of such an offence and that he is not likely to commit any offence while on bail. And also by this amendment, a power has been given to the court that once a person is arrested, then whether to grant that person on bail or not, this will be the total discretion of the court. And in case if the offense of which he is accused of is more than 3 years, then a notice has to be sent to the public prosecutor to give him a chance to oppose the bail. And the magistrate will and the special court will only grant bail if he is of the belief that he is not likely to commit this kind of offense while he is on bail. The above amendments to the Prevention of Money Laundering Act 2002 brought in by the Finance Act 2019 brings a much needed clarity on various unaddressed aspects of money laundering. It can be said that these amendments can now confront the authorities with better command regarding investigation, seizure, search, confiscation, closure and adjudication. So over all these powers, now the investigation officer can take its own discretion. So this is the end of the slide, and I hope you all have liked it. Do not forget to give a like, share and subscribe to the channel. If you have any doubts, query or any other feedback, you can share the same in the comment section below. So with this note, I am signing off. Have a great day.